The Alternative Dig Talk. Real issues, real talk.
Fellow citizens, following the sequence of events, Uganda seems to be at political crossroads.
I'm not a servant of anybody.
Madam, I know the law.
As such, Alternative Digital brings you the Interface Show with retired Colonel Dr. Kiza Besuje.
Let's keep on the same page on Alternative Digital.
As he gives you the alternatives on the transition question, rule of law, human rights and freedom, youth inclusion in governance, economic stagnation, as he confirms.
I'll be always here, Saturday from 10 a.m. in the morning. Be there.
Don't miss the live discussion on the Alternative Uganda, Digitalk TV Facebook pages, and the Alternative Uganda YouTube channel.
The Alternative Dig Talk. Real issues, real talk.
Good morning to our viewers. You're most welcome for this show on this lovely Tuesday. I take this opportunity to welcome you for this yet another show, Tekachi, that runs every Tuesday from 11 to midday. And as we promised, we keep on bringing different guests on our shows, different shows, to talk about issues that affect our day-to-day lives. And this is the Alternative Digital, streaming live on our Facebook pages, the Alternative Uganda and TikTok TV. We are always live. You feel free to share your comments, to like, and also share the same show with the rest of the viewers out there. I am not alone today, and I have my other fellow guest, Counsel Alfred, who will introduce himself later. But before we go any further, I want to first take you through the legal alerts that have been making rounds this week. And we have had a number of judgments and rulings set by the different courts, starting from the High Court to the Court of Appeal and then the Constitutional Court. And among the interesting ones, we have the famous case now that has become famous about the constitutionality of the offenses of rogue and vagabond. If you don't understand the same cases, the same offenses, sorry, these are the offenses under the penal code that include the famous known as chireres,
Yeah, rogue and vagabond.
the rogue and vagabond. You are idle and disorderly. That's the famous word they always use to term the same offenses. But the Constitutional Court, in the case of Francis Tumwesigye versus the Attorney General, it has been clear and declared the same offenses as null and void and unconstitutional. So therefore, feel free to do whatever you are meant to do, and not fearing of being arrested for being idle and disorderly. And among the issues raised was that a person cannot be criminalized for his or her status in the public. For if your status is, for example, being a stout at a taxi stage, then how do you be idle and disorderly when you're doing what you're meant to do? And that is your status. So it is now a clear one. And then the other one is about sentencing and how these sentences should be pronounced by different courts. In the case of Sundia Muhammad and 563 others versus the Attorney General. Remember, that case is the famous one that included the late Bob Kasango, yeah, so many other people came up to challenge the different provisions and how the different courts had pronounced different sentences and convicted them to serve different sentences of about above 27 to 70 years. This had been a practice since, the issue of life sentences had been taken a little bit slide. So the Constitutional Court has declared and ruled that the same are unconstitutional, and it brought all these sentences of over 27 years to 70 to also fall under the provisions of serving a sentence of 20 years in prison. And then the other one was in the President Museveni versus the editor-in-chief of Daily Monitor and Daily Monitor Publications Limited, and the issue of staying the hearing of the suit in the lower courts pending the constitutional petitions to be heard first. And Justice Musa Sekana has been clear, and he said that the lower courts can never wait for the constitutional courts to make their rulings, and the same would amount to increased files and cases in the lower courts. So those are the positions. You could look out for them and keep yourself informed about the different developments in the law. And today in our topic we shall be analyzing the employment laws in Uganda. And today our best interest is, and shall start from how these employment relations are created, how they are dealt with, and if you get tired of working for somebody, if that employer gets tired of employing you, what is available for them and how can they end such relationship? At the end of it all, if these relationships end, what are the remedies available for both parties, the employer and the employee? So this is what we shall be discussing in our today's episode and show. And allow me to introduce you, Counsel Alfred, and say hello to our viewers so that we can start our discussion today.
Yes, thank you, Counsel Muyaaka. Yeah, my name is Muyaaka Alfred. Briefly, I'm a lawyer, a passionate teacher, and passionate at civil litigation. My areas of interest are civil litigation, land transactions, and employment law.
Okay.
Because why they are? Because you see, I firmly believe that the employment issues, the economy rests so much on employment, and that's why people are crying for jobs or what. Everyone wants job creation. So after employment, all of us want to own a piece of land or what.
Yes.
And before you know it, you end up in court, either because of the job issues or because of the land transaction is going bad.
Okay.
So that's how you end up with the civil litigation part of it. Then with being a passionate teacher or what, I'm a born of parents who are both teachers.
Yeah, okay. That's
who always wanted me to be a teacher as them. And because of it being a noble profession, and I said maybe I could take another noble profession.
That's how we ended up becoming
a lawyer. But still, I teach. Maybe I use my social media platforms to teach. Like for the Twitter handle at Muyaaka Alfred, you'll see there are those Dear Young Lawyer series. I think most of them
actually, our viewers out there who are fan of Twitter and who follow much and use Twitter, you should have heard about the famous tweets about Dear Young Lawyers. So this is the brain behind the courts.
Yeah, the Dear Young Lawyers.
The encouraging words behind Dear Lawyers.
There are even there's a full thread for like law students. I recently made a thread for students passing LDC. It's not conclusive, but those were tips which could be used. And I was lucky enough, it was even published in Daily Monitor newspaper and New Vision. But in case sometime back, but recently, but in case that you can't access them, the Twitter handle of Muyaaka Alfred, you can easily, the thread is there pinned for both, and then the Dear Young Lawyer series is a daily series. You keep having one thing per day. So that's one way of teaching. And then the civil litigation and employment thing and land transactions, that's my...
Yeah, you could even tell the viewers the firm you work
Yeah,
with?
yeah. I work with Kaikumutima and Company Advocates.
Okay.
It is on Pillington Road, Collins House.
Okay, that's
Yes.
so nice to host
Yes.
you today,
Yes.
Mr. Alfred.
Thank you,
and
sir.
Counsel Alfred. And today, like I introduced our topic, we shall be looking at these employment laws and how best can we handle the same issues that regard with employment. Because we understand that at the end of it all, in whatever you do, either you are the famous called casual laborers, employed people who have contracts and the rest, we all are governed under the Employment Acts and the Contract Acts. But before we start the discussion, I wanted to start from a point of telling our viewers how are employment relationships created in the first place.
The employment relationships are created ordinarily or basically.
Yes.
Ordinarily, when an employer or a person wants to employ someone,
You can mix in some
Luganda
for the interest of our
for our Luganda viewers
our
or what.
Luganda
And so ordinarily, muntu ayagala okuemploying omuntu advertises for the job. Your people, you apply for the job, interviews are made, so the person who passes the interviews is employed, usually first on probational basis for 6 months, and for if it's on, the contract is on probation, it should be explicitly written down and even noted that's for probation.
But before we go to the probation bit of it, is it mandatory and is it a requirement of the law that before I employ Alfred
Yes.
as my employer here at TikTok, do I need to make interviews? Is it a provision of the law?
It's not a
Or
provision
that
of
is
the law,
practice?
but it is a desired practice. You know, we have Gambanu go as someone others call them where it's just a call and you come and work.
Okay.
But so it's not. But that's why I said ordinarily.
Ordinarily,
You
okay.
do advertise for a job, people apply, come do interviews. So you are given a probational basis. Yeah. That's the contract, which is it should not exceed 6 months, and it should be explicitly written down that you are now on probation. So
it must be in writing.
in writing with the heading to that effect on probation. So once the 6 months expire, you're not supposed to again give another probational contract after 6 months. Anyway, with the employee wakiliza or the express employee accepting, you could give him another 6 months, but now you don't end there, and then now you go into the permanent employment after the 6 months.
During the period of probation,
Yes, yes.
is there any payment remitted to the side of the employer?
Yes, there is
The
payment.
employee, or
There is payment remitted to the employee because somehow how would you want to work without? Okay, even though you're on probation,
yes.
how would you want? How will your employees survive or even be coming to work on a daily or what?
Okay.
So there is payment to that effect.
So after the expiration of the probation,
Yes,
what
yes.
happens in that kind of
Such a situation of the probation. Now, if you have passed the probation period, so because probation is really more or less testing you, can you do the work we want to employ you for?
So it is like a learning process. at
Learning
work.
process, orientation process. So after we have seen that actually you are a good fit for our company or for this job, then we put you on a permanent contract, which could be in writing or what. But if you feel like you didn't satisfy us, you could still have you terminated at that point, but that would be done within, I think, 14 days before. If you are ending a probation contract, it should be at least, you give a 14 days notice before it is ended.
So together we have time limits and time frames during that relationship of probation and how to terminate the probation.
So if there is probation and now you're seeing the 6 months are coming to an end, and you feel you want
this person will not meet our qualifications.
Our qualifications or didn't meet, and you want to terminate it, at least you give him a 14 days notice. Muganda ye sorting omwatayimu naye yategeera nti anoonyeko awalala. So if wabanga ayisemu, that's when you come to the major basics. Now you have the employment contract, which should only be in writing.
So now when we talk about the employment contract and that is in writing, what are the basic features that should be looked at in the same contract?
You look at, obviously, the name of the parties. You look at the work you're supposed to do.
Should be specific.
Your job title, even the job description, your wages, how much are you going to be paid. You reach a point of what is expected of you as my employee, and even what can you expect from the employer, as in terms of benefits, what your things dealing with your leave, working hours, from when up to when you are going to work. Even now, you can even put a termination clauses if you need to terminate this contract at the end, because it's not a permanent thing that maybe I'm going to work for one forever. Even you may not, say either way, the employee may not be going to work with you
for life.
It's not permanent and pensionable. Even the employer will not be wanting maybe to work with you forever. So you could put even those termination clauses in case you want to terminate. How should it be done? Or the notice period and the like.
So we have this employment contract written and for example, maybe signed between the two parties.
Yes.
And I should say, they give me a copy of the same contract.
Yes.
And you also have a copy as the employer and the employee.
Yes.
Is it a matter of taking it home and keeping it? What do I do? Like a common citizen, what do I do with this contract? Do I keep it under my bed and say that I have a contract and that's the end of it? What else is required? What should I do with that kind of a contract after signing? Obviously, keeping it is one. You are supposed to keep it because at one time you will need that evidence that you have ever worked here. That you have ever worked and you are an employee.
You are an employee. And aside keeping it, you need now to, because now your terms are specified in the contract, your working terms and the service you are supposed to offer. So you need to fulfill those terms. And even it gives you proper planning, because the employment contract to have the timeline, like you're going to work with us for 6 years or what. So it gives you time to plan that, okay, I'm going to be here for these years, and this is what is expected of me while I'm working here. And so you can even mean to plan your next plot after those 7 or 6 or 4 years, that effect.
So it doesn't matter where I put my contract, as long as I know the contents of
what matters is you keep it secure. Where it's secure according to Guava money. And beyond keeping it secure, you may need to keep looking at it and you evaluate yourself. Like, this contract says I do this and this, am I complying? So that you're not caught on short guard that you are underperforming just because you didn't look back to your contract and realize that actually I was expected to be doing this and this and this. And because I just kept it there, I forgot about this thing. So somewhere you mean to keep referring to it as you evaluate yourself. Or even
and see how you are performing.
How you are performing. And even evaluate, because now the contract is of both parties, and even evaluate your employer, because, okay, so you see, like, I'm performing, but now, is the employer also doing his part? Is he paying me as he promised? Is he these bonuses, allowances, or what? Is he are both of us complying with this relationship, and how can we better go about it? Yes.
Now, on the issue of specifying what you are supposed to do and then the time for work.
Yes.
I will give an example, and maybe this can help our discussion. I am employed at TikTok to be, for example, a host of a show like Tekashi, and it runs on Tuesday at 11.
Yes.
And maybe because of unavoidable circumstances, I am called on a Friday to host, for example, Voltage show.
Yes.
That is not made. That wasn't
that's part of
described in my contract. My contract was for Tekashi, and now I am being called by the heads to come and host a show on a Friday.
Yes.
How is that dealt with under the same contract?
Usually, in the contract, you have those incidental duties to employment, and as an employee, you undertake as and when needed, because that one you see is a rare occasion. It's not a usual occurrence.
It is not usual.
So as an employee, there's always that clause of incidental duties to this job, and as and when you needed, you can mean to patch in, because it's a one-off.
It's one-off. So incidental occasions that happen.
You patch in. So when Motegulina come out, because Wagamba, I should only do this and only this. Because that is typically saying that, because even me now, your employer, if I reach a point and I want to give you beyond what I'm paying you, and on Sanyu Caesar, I want to give you a tip, I should not give you because the contract says I'm supposed to give you this and this. So it is either way.
Katugambe nti okumpa omulimu wano okukola eno show. Kankize mu Luganda so that our audience out there can typically. Okumpa wano omulimu okukola eno program. Ebeerawo buli lwakubiri saawa 5. Nina okubeera ku standby every time. Ne ku Friday ne ku Saturday esaawa yonna osobola okumpita.
No,
depending on that cross that you have mentioned.
Incidental duties.
No, incidental duties.
So kati
kitegeeza
kiriwe kiti kati mukwado omulimu nti okola saawa 5 waneno. So ekyo kiwa deal olina kubeerawo
kiwa deal buli lwakubiri saawa 5 era nkola.
So where it comes out nti waliwo ka emergency nti nja kwetaaga ku Lwokutaano. I should notify you at least nga bukyali kugambe waliwo ka emergency. So
that there is an but
that's emergency. Emergency. So at least it reaches Thursday evening ngambe, you know what, akola show yo Lwokutaano taliwo nyambo shipingewo okwo
kati okuba kuyamba oba
no you can
oba gwe mulimu ogubeerawo
no sino omulimu ogwakisaganya okubadde gwa because okay just imagine nti you work Monday to Friday then before you need it now let me use my legal work. I'm supposed to work Monday up to Friday. But before you know it, there's now this client is coming to Ajamugwanga or is leaving on Saturday ngayagala kintu kye ku Saturday. So obviously I know your job is Monday to Friday, but there's waliwo aka emergency ketwagala otukoleddeko ku Saturday. Obviously it is just courtesy between both of you that you should do. Now you should be flexible enough to go and do the thing.
So in the instances that I don't accept the same call.
You don't accept the same call.
Have I breached my terms of the contract?
Obviously.
How do we term that, Mateka?
You have not breached the terms of the contract because they are clear. But
am I against any rules of employment?
You are not, because the contract was clear. But you see, before you usually go to the law, you take and call the law say no gamba kati obuntu bulamu. Obuntu bulamu. There's that thing of ubuntu spirit. Yeah. So this is my employer who is maybe treating me well. Naye angambye manyi tutotera kola ku Saturday naye jangu just lero. So that thing of ubuntu spirit. So that now next time we yagala favor from him tajja kwera ka off ka Tuesday ajagamba genda kuba nange wenkuyita on other days you come naye okiyisa woti onta nze sijja ku Saturday tebiriimu tegeza naye olikeera ngo oyagala ka off on another day nange njagamba nedda you're supposed to be here Monday to Friday. So it is a two-way affair.
So it is a two-way and it is upon and dependent on how the
relationship is and so you live now there you just put the last side and the contract and you go to Ubuntu spirit.
Okay. And serve as you are required to serve.
Yes.
Okay. That is cleared now.
Yes.
In the terms of contract, the same contract, we state and clearly specify that Kato is working for Alfred for this period of time, and this is his monthly pay.
Yes.
And for example, his monthly pay is 500,000 shillings at the end of the month.
Yes.
And that is what is clearly stated in the contract.
Yes.
And there are periods where we do what we call overtime. We work overtime.
Yes.
How is that treated under the law?
Actually, now the contract.
Is it also considered in the same payment of my monthly salary?
No. Well, actually, most contracts there is overtime allowance.
It is
situated in the contract. But if it's not stated in the contract, you're supposed to pay for it.
So how do I claim that I have worked overtime on Monday and now?
Yes, how you claim is the employment contract is telling you working from 8 to 5. So the moment I'm going up to 7, so that it has become overtime. So you're supposed to pay for that overtime allowance. Either
so
now depending on...
It's a matter of walking to my employer and telling him that today I've worked overtime, so I need my...
Actually, most companies, when you work overtime, you can meet tuition for the money. That on such days I worked overtime, and because even this is the time I signed out.
But is it even feasible and applicable in our country?
Now that is, I've not made that research to be conclusive. I could state that it's not feasible, yet there are people doing it. So until I make research that in fact, that's when I can say it's not feasible, but I can't doubt it because maybe they are there, the people who do it. Yes. And
so that's in regards to allowances?
Yeah, overtime allowance.
Overtime allowance.
Yeah, because...
Which other allowances are provided for?
Yeah, there are those bonus payments, like you have done good work and even agreed on it. Now, like for our, let me say for, I know I'm using that because of the money. Okay, let me use teachers because I was supposed to be a teacher. Okay. So there is a teacher, his duty is to teach, but he was saying, he was promised that later abana webayita ne bafuna such grades.
First grade.
Weziti. Tugenda kwongerako akasente. So those are kind of bonuses depending on how. So you have your performance rate, you have to contract, you're supposed to deliver to this extent, but some will even deliver beyond that.
What is
expected of you. So if you get a bonus as sense of appreciating you for delivering even beyond expectations.
Okay. So we have the overtime allowances, the bonus allowances. Do you have any other kind of allowances provided for? Maybe under the law? Or
under the law, we have, but the others may come after maybe the contract has ended, but under the law, basically we have more or less bonus overtime. And under the law, you have others contributions for NSSF, because we are employing
I wanted to ask you the same question as well. Because when we are in employment, we are charged taxes, the pay as you earn.
Yeah, pay as you earn, yes.
We have NSSF contributions. Who bears the duty?
It is the duty of the employer to pay all those duties. And actually, for now, like for NSSF, the employer, it's criminal for the employer not to pay it. And it applies where you employ more than 4 people. You are supposed to remit their NSSF on a monthly basis.
That is a provision of the...
Yes, and where you don't pay, it's even criminal for you not to pay for NSSF.
So what about the companies that don't pay NSSF for us?
You can report to NSSF and they go about it.
They go about it.
Yeah, because NSSF were approaching Wagambe, we have got
information
you employ more than 5 employees. Now here we don't see their allowances, NSF benefits on a monthly basis.
Okay, this is Counsel Alfred. Today I'm discussing the different relationships in the employment. And my other question is, because we have now dealt with the issue of employees who have contracts.
Yes.
But we have these, I will use a common example of these people who Baba Itaba Porter.
Baba Porter, yes.
Yeah, I think you know that. Right?
Yes, I know.
They have no contract, but they work on a daily basis.
Yes.
And for example, most of them work with specific individuals or companies.
Yes.
And they know that they have a building that will last for example, for 1 month. And this person goes on and on every day. How are those categorized, and how do we deal with them in regards to what they are supposed to get and benefits?
Yes. Now there is you being a porter when there is an
I give that one as an example.
Okay, I think to bet I'm going to come to you say. Now there is you being a porter, but when there is an independent contractor go the project ngaya kusasula. Now there is you being a porter on my building naye nga nkulabanga tubayite ba casual workers akola emirimu gya bulijjo lejja kangambye. So ng'oli mugamba I'll be paying you on a
mutwalo buli kanaku.
So the first basis for me to be umuntu qualifying okubeera casual worker olina okuba nga omuwa sente ezo buli at the end of the evening nti enkola olumala ng'ompeerawo and that should not exceed for 4 months. So the moment I worked with you in regarding olowooza ndi casual worker and I exceed 4 months, mbasikyali casual worker.
Kati awa wakutaminga nga
mba nfuseyo permanent employee.
Naye nga buli kanaku buli lw'okoze nkusasula sente zo.
The basis is that should go on for 4 months.
For 4 months. Beyond the 4 months, then I qualify to be your
permanent employee. So you can even mean to say kati wange nakuwanga at the end of the month. You can even mean to be paying me. Naye kati just chikupeera mu bwongo nti kati ndi your permanent employee.
That is what the law provides.
Provides casual laborers should go on for only 4 months. The moment you go after 4 months,
then you become a
permanent employee of that person employing you.
We have had instances where such casual laborers are not paid and their allowances or pay is not remitted at the end of their work.
Yes, yes.
How are they helped under the law?
Yes, now when you are not paid, I think, actually, maybe let's just generalize it into you have issues with employment.
We have issues and
the,
we need them to be resolved.
So the first point of recourse, a labor officer, each district has a labor officer. Now, like you may find in Kampala, Waliwo, Nakawa, there's case labor office. You find in Jinja, the Jinja district labor officer, where. So the first point is go to the labor officer to file your complaint, our labor officer.
Okay.
And when you file it, they register it, you serve it to your employer, in a response, and then you have a hearing, sort of labor officer handling matters with their logical conclusion. Nice. Once any party is dissatisfied with whatever's come out from that, then you request the labor officer to refer you to industrial court.
So most of these casual laborers have no contracts, and that sometimes it's hard to prove the relationship that they are working for A and B. How is it resolved and how best can we help these casual laborers? Because I know some of them could be having issues at their workplaces.
Yes. Now the first thing, the contract, sorry, the Employment Act is very clear. Any employment contract can either be oral or in writing. So even no one at all in writing, you still have that oral contract. It even goes further so that it can even be implied. So whether written or unwritten, I have a contract with this person. So that's the first basis. Now, how will you prove your being employer?
Being employer.
The first thing, this person has been paying you money. So if
but this is the money I pick out of the pocket
and I pay. So
it's hard to prove that,
he has
whatever
been
I am giving you is actually for the employment that you are offering.
Yes, and we want to prove the employment relationship.
Yes, actually, Counsel Alfred is my employee.
So it is now the employee proving to them to whoever is concerned.
And I want you to highlight a few issues on how this employee can clearly state and prove that I have been employed by a person A and a person B.
Now, if this person is paying you cash in Gambi, what you have the major basis is to qualify the thing that this was an annual employment contract and I've been working. The second bit is people have been seeing you working for that person. So you can bring those people. The third bit, this person has been paying you money. So now there are those who could be paying you via mobile money, has been paying you maybe there are those who account numbers and just transfer, So I've been paying you through electronic transfer, bank and account number to just take angoko. So you have that proof that he has been paying you in the bank. Yes. So it's like, no, he's been my employer, and you see these are my pay slips he has been paid. So even without the contract, these are the pay slips. So you can't mean to deny that, I'm not employing him, because then you ask, so this money was being paid for what?
Maybe you sold me some of your goods, that's why.
So you have been paying it for a period of 4 or 5 months, slowly.
Yes, I pay in installments.
Then you leave it to the labor officer in the industrial court to decide whether now it is so that. But that's the best how you can prove that you have been employed, even without the written contract.
Okay. Okay. I think that's clear to our viewers. Now, let's rush, and I will use examples, for example, for purposes of our viewers to clearly identify and get to know what we are dealing with. We have had issues where a company or an organization employs for over about 50 people. And because of different issues, for example, on their income inflows, and outflows, they feel they cannot manage the big number of employees.
Yes.
And they want, for example, to terminate their contractual relationship with about 20 or 30 people at the same time. Yes. I want you to take our viewer through how the same can be done. To terminate that kind of a relationship.
I think the law allows you, the law allows you to collectively, because you want 20 and above, terminate more than 10 employees and above
at the same time.
but you know your collar before you do that. So the first thing you should have, there are always 3 reasons for terminating collectively. The first thing could be economic reason, was Gambia. Then technological reasons, and then maybe another reason which could be justified.
An epidemic.
A pandemic or what. And then now we want to terminate more than 20. So the first thing is now you report to the, you write to the labor union at whatever employees clearly stating the employees were going to terminating, the employee is going to be affected. And even you state their names, particulars, benefits were going to in that same letter. And that process should take take a 3-month period. Tomorrow njaga terminating 2010 and above, I just rate terminating these are the people I'm not paid, these are their particulars, and these are the reasons why I'm terminating them. So it is a process until you 3 months. You notify the labor union ebatwala because she being in the category of employees, baba ne category ebatwala. So you write to that labor union, then normally you still also notify the commissioner for labor. Still the people you're going to terminate, the reason is their particulars and everything, and that should take that should be within a 3-month period. It should not just be a one-off.
Sign and be like actually starting next Monday, your contracts are terminated.
Because the major thing is you need to have that timeline of 3 months for muntu sorting mpola because you see the procedure we are following when we are employing someone. You saw how it was. You have applied interviews. So in the same vein, when you are terminating, you should have that sort of procedure. And then here, your actions are not only affecting only one person, the employee. The moment you terminate me, for example, it's affecting maybe all the dependents who depend on me or what, family. Even me, so whenever an employee is terminating, you should first think beyond me, the person is being terminated. Or what, you should first think about the person you're terminating. And if you think even beyond me, that I never depend and so what. So that should create that timeline, 3 months, so that if I have a family, I put them to terms that, but I'm restructuring because of this.
So I need to get some. Now talking about the same issue of notices and informing them about their termination. Let us now deal with the people with contracts.
People with contracts.
And how such contracts terminated. This is on an individual basis, not as a group termination. But they want to terminate Alfred's contract. And the issue of notices, how is that dealt with under the law?
Now you see, when we're in the contractual relationship, to get having a termination clause, a work term, work termination. So it could be that if you want to terminate me, you'll give me a 2-month notice, or 3-month notice, or 4-month notice. Actually, either sides,
that is when the clause is stated and stipulated in the contract.
It should be there in the contract that you want to terminate me, that's what will be done. This period. Now, if there is no termination clause to that effect, then now we go back to the Employment Act, depending on.
Now let us tackle the Employment Act.
Now, depending on the period I've worked with you, determining notice period jogendo kumpa. So there are those who 1 to 3 years I've worked with you for such long, you give me 1 month notice. There are those who qualify to get 3-month notice. But actually, abasingayo obungi qualifying for 3-month notice. But even to avoid everything, was the law now time frame GM 1 to 3 years, 1 month notice, between 3 to 6 years, and 2-month notice, and then 10 years and above those 3-month notice. So we are in a timeline depending on how long I've worked. But it would be prudent enough, even if I've worked. Now this is my take. Even though I want to work for more than 10 years, we still go back to those 3-month notice basically. Because those 3 months allow you the first thing of sorting, and even okutandika okunoonya omulimu awalala. Actually, in that period, you're supposed to even be required to work half day. So that, yes, I work half day, mukolo omulimu ogwo, then half day, sinakugenda wakamba nti ndi kunoonya kawogo kalala. Akawogo kagenze. So, that period is supposed to work half day. So that's one of the terminating bit. Then there was termination whereby the contract was for 2 years. It was express. So ziweddeko emyaka ebiri. So you're good to go. Then there is that termination into age limit.
And you're past the...
Yeah, you are past the age limit. Yagamba for this job you should not be above 65 years. So then when you clock 65, tolinda navidde. Nga that otugamba nagamba nti ate njagala notice with that 65. Then there's even death. Because when you have the contract egenda komaawo. Yes.
So what is included in the same notices for termination?
Yeah, in the same notice for termination.
Should there be reasons or?
Yeah, there should be. You see, there should be reasons for terminating, because at the time of you employing me, you had reasons for employing me.
Yes.
So even at the time of terminating me, it's only fair that you include reasons for terminating me. So that's the first thing. Because so that even though I'm looking for another employer, at least if you ask me what is your employment history, and I'm like, I worked with so, and maybe terminated my job because of these reasons. So in a year, maybe the contract was done. You get those things. So there should be at least reasons for termination. It's just fair until Muntu should know why an action is being done against him. Then they should now you explicitly state the benefits, cover my benefits in between there. If I have the salary wages, there's no thing of repatriation allowance in Jawala to come and work for you. If it's above 100 kilometers from, let me say,
the place of work
from Wanzija, then there's that. They know Kudayo Geneva. So you should look at that. You should look at accumulated bonus payments.
So those are some of the benefits.
Yeah, upon the termination. Nange newe mba njagala go terminating. If I request you pay Chebeda certificate of service, the client have worked. So we know because now that certificate of service is proof of employment that I've ever worked with this company. So if I have my CV showing nakola no, ndina proof that church of nakola. So when employer requests for one, when a certificate of service.
I will give an example from one of my viewers here, and then he states that council says the same agreements, the same notices should be in writing. What happens and how are the messages, SMSs and WhatsApp messages of terminations, how are they treated? Do they qualify as termination notices, or that's a different issue?
You see, before you even start qualifying them, when you are employing me, did you send me a WhatsApp message that I've employed you and these are the terms of the...
But the relationship and the communication was different at the time of my employee.
So there was no WhatsApp and the like.
But today I have your contact and we use WhatsApp, we use WhatsApp forums and
so
they can ease our communication.
So you want to send a WhatsApp message that I've terminated you and these are the...
That is a question and we need your advice. Legal advice on how. Is it still treated as a termination notice?
No, because you won't be treated as a termination notice. Because basically, termination should have, now for like a company, there's a company headed letter or what. At least should be on that headed letter, when fully signed, stamped by the person issuing it. So I don't know how you're going to issue or to sign on that WhatsApp message. Or even I can mean to use... imagine, okay, my Airtel is on WhatsApp, and then your employee uses your MTN to send so another person uses your employee's MTN number and you send a WhatsApp now because that thing. So you don't even know that actually it came the employer, actually even the employee himself or herself, or if you can the termination was not lawful. You know you're challenging it, you can even mean to deny the message into this is a demand. Go check or go yasin kabala yajira yakinga simu yange na kugoba nawe nolowoza kugobe but since yachikola. So it's only prudent that it's waiting ku ngevude employer mwenyini
so that it can be easily proved.
Proved.
So we talk about terminations and they are what we normally call unfair terminations.
Yes.
And the employee feels that their termination wasn't reasonable and it was unfair.
Yes.
And then now, as we run with time, I want you to take us through the remedies that are available for such unfair termination.
Yes, so for unfair termination, yeah, this is another of the first recourse is to complain to labor officer still in the area where you are.
So in the employment, conflicts, you don't run to the chief magistrate's court.
You don't run there. You only the first recourse the labor officer.
Okay.
In the place wall, like Sinti, Tuja Kuvera Jinjo, labor officer we Kampala.
So in the area?
In the area wall, the nearest labor officer. So you complain with your reason is why you're saying you were unfairly terminated. So ngawe twaga the labor officer now will summon the employee. Wajamu that you almost fail your complaint, you will write a letter to your employer, you attach your complaint, and then someone requiring it can be served to employer na ya take the response to defend it. Actually to me it was unfair because waliyo bagamba tusalangwa kalanga tunawulira gwa kalenzi so kati gwa kawala gwe gonti bangobye mu bukyamu so kati bagamba no gwa kalenzi now you can also tell us wamgoyo mu bukyamu oba nedda. So the employer also says the employer nagoba mu butuufu. So now you hear both parties now. So if the labor officer now see party winning, he can. So the party who is dissatisfied from decision of the labor officer, then in the labor officer referring the matter to industrial court.
So from the labor officers, the court of first instance, we go to
industrial court. It's a decision of the High Court, specifically dealing with only employment matters.
So we don't have to file our matters relating to labor disputes to High Court and the magistrates.
As the first point of reference, no. As the first point of reference, you should file with the labor officer. Then you go to industrial court.
So where, for example, the labor officer or the industrial court finds at the end of its finding and hearings proves that I was unfairly terminated, what are some of the remedies and the benefits that I get for that unfair termination?
Yes, the remedies, the first thing is the general damages or for that inconvenience. Bakuliyirira. Yeah, now that one depends on how much you are earning and even the position you are, you are only at time of termination and the inconveniences which you have faced as a result of that unfair termination. So if at the time of being terminated, you are over salaries, arrears, bazijira. If at the end of termination, you are supposed to be paying for any necessary then even for you in handling this matter, you have incurred costs in terms of hiring lawyers. Even though you didn't hire a lawyer, maybe you personally had incurred costs okutambuza omusango nazo bazikulirira. Yes.
So these are some of the
those are some of the remedies.
I want to go through a few comments.
Yes.
I see some viewers. Maganda Anit saying keep up the good work. And then this is Inaman Junior. He says that you are his mentor. Then Annette, they're all giving up and saying thank you. This one asks Counsel Alfred, talk about the issue of NBS. I think I saw you trying to advise. This is in relation to your dear young lawyers on Twitter concerning the issue of NBS and
the issue of NBS and termination. No one. You see, I've been in practice long enough to understand that you can't proceed unless you have the full facts of the case.
Yes.
So I can't. Until I've heard from NGS employees, I don't want to comment, fully comment on it. What was there was just a letter, because the letter which was on social media was letter was dated on 30th November, and then they were telling them to stop working on that same day, 30th November. So that was the only thing, but you don't know what maybe transpired before that letter. They could have been given payment in lieu of the notes, because where you can't give notes to an employee, of the 3 month notice, you can mean to give him that salary you would have got in those 3 months. They would have been given that money. Or even them, they would have said, no, nothing to call, no, to go. So until you have facts from the other side, you can't mean to really go deeper into debating about it.
Yeah, this one was saying that he got it from your Dear Young Lawyers series, from your Twitter handle.
Yes, yes.
And thank you for that response. And Carl Derrick is watching as well. Say thank you. Yeah, I think those are some of them. We don't have so many questions in regards to that. And
all the issues have been answered.
yeah, I guess they are taking something important from this. Now, we have looked at what the labor officer can,
yes,
can give in regards to unfair termination. And as we have talked, that the termination is on both sides, both the employer
and the employee. Yes, yes.
So this one is on the side of the employer. Employee, sorry. He feels that he has been unfairly terminated. And what about when the employee himself wants to terminate the contract? And for example, the employee feels that this termination is not working in my favor. Do they have any remedies available for them? On the side of the employer. So I want to terminate my contract
as the employee. Yes.
Because I don't want to work with you anymore. And you feel that I am being unfair. For example, I've given you 1 week and I say, tomorrow I am not coming back here. Do you have, as an employer, have remedies as well available for such kind of termination?
The first basis is you go back to the contract that was signed at the beginning. So the contract it can be specific. Now, either party wants to terminate should give me this period. So now an employee who thinks anytime ngenda question mulimu guno kuba I don't think talking about case no gamba guntami something which builds up nti mwana wano natera ovaawo. So you go back to your original contract no lava termination clause yali egamba banga ki okugira so you give that notice to employer and mukama wange anytime mwezi gumu okuva kati oba myezi ebiri ojja kuponda byeko because the way we are asking for employers to be fair to the employees, even employees should be fair to employers, because employers take also time when recruiting people. So it's not, now you leave even the last side, we go back to Ubuntu. It's not fair to just come and wake up, your program, you take you just come tomorrow. So it means employer will less out and not having a replacement, don't want a time of no replacement or what.
That in case I terminate my contract that way and I wake up today and be like, how many? Does an employer also have the same benefits?
Yes, can also, not the same benefit. An employer can also
the same benefits in regards to remedies. Remedies
na you can also complain.
The labor officer
yes, but you know because of his could also face damages. Because it means no gamba take a chimba vehicle. So it means another maybe a month before I get it, because
before you get
a replacement. So civil your money again appearing up to take a so that inconvenience has me. And then even when to die contract tinti wagamba twakirizaganya wowe yagala kugenda olina kumpa this note. So even me, either party should have as capacity or the can I call it locus buli omwe alina obuyinza complaininga labor officer nti nange ono yakozeemu ensobi. Though most employers don't do it because bagamba actually the world will teach you genda kaneye ebyange because and eventually somehow it teaches you, because there's that thing of karma is a bit I deserve they state it. Okay, what you reap whatever you so sagamba genda maybe nawe bali chikukola because you know not everybody should be fault. So the employers are busy, they can be gamba no, I can't fight that battle with an employee who wants to leave. I was our chitalo nyonga walowooza akwesonyiwa, but
they can also have other
yes, that
avenues.
avenue, that same avenue.
Recourse.
Yeah, because it's only fair that since you can pay the matter, actually that was the matter you were talking about in the at the beginning of Museveni and Daily Monitor.
And Daily Monitor.
Since Museveni can mean to be a complainant, so
then he should be a defendant.
yes,
So it doesn't work one round.
It's not a one-way traffic. So
It's
since
a two-way.
it's a two-way traffic, since the employee can meet complain against the employer, so even the employer should also complain against the employee.
Thank you so much, Counsel Alfred.
Yes.
And I will give you like 2 minutes to say your final words, advice to the dear young lawyers. They can also pick it from the same as we call it the end of the show today.
No, the dear young lawyer series, I'm not promising them heaven on earth, but there is much in store for them. They just follow the Twitter handle, because that one, it will show is just click that follow button at some. There's much in store for them, and see the dear young lawyers, it's a constant. Maybe some of us who are lucky to learn these things early in life, and we think that if others can learn them as earlier than even before us, they can get better, because we don't get chance to meet those mentors we want. Lawyers are too busy or what. Even me, you may meet Katingoya Agambye I'm his mentor. Actually, I've never met him physically. But so because we can't get time to meet physically all the time, so use such platforms to mentoring also.
Well, I should ask this, and this is somehow personal. Where do you get such motivations? Dear young lawyer.
The bad thing is,
have you faced the same, or did you have other people who used to tell you the same at the time? Or
now me personally, I was lucky to be mentored as early as possible, because I started working in 2016. So, and from the background base, because I started as a law clerk, like a legal clerk, to legal assistant, to now an advocate. So for me, I've been in the trenches, everywhere. So in those trenches,
so basically, you know what young lawyers go through.
Not even young lawyers alone, but anyone in the legal fraternity. What I know, what in the trenches, you see, whereas most people would have been from just went to law school, bachelors, and then backwards, and then they start working. Now you are really from trenches, from freezing from A to Z, legal clerk, what. So I know what is in the trenches, and since I managed to get out to reach to this stage, and then there are those who are at that stage, and then people who want to be mentored, they can't mean to access them because of their busy. Not even those people are not available, but they are too busy. And mentoring or teaching is not everyone who's talent or what, or everyone who's calling. So that's the motivation that maybe this one should learn this as early as possible. I was lucky to learn it as early as possible, and it has benefited me a lot. So it's only fair that I transfer it to others, so that maybe the trend continues, and you never know, one time we'll change the rhetoric, and by the time people come out of law school or from start their practice, they have the best knowledge to kickstart their legal practice and anything in their legal fraternity, something of that kind.
Okay, thank you so much. This has been Counsel Alfred Muyaaka on our show today, Tekachi. And as we promised, our role is to bring you different people to always share their knowledge, share their experiences, and share what the law stipulates and what should be done, how it should be done, and how best can we use the information that we know as people to shape the communities that we live in and the country at the end of it all. It starts with me and it ends up with you. And as I've always told you, and I repeat it, don't keep this knowledge to you alone. Because even if you keep it to yourself alone, it will not be helpful to you alone. And when you share the same message and the same knowledge, it helps so many people out there who may need the same information, who may need the same knowledge, and it can help them in one way or the other. I like the motivation of the dear young lawyers. We still have a lot to share to you, and you know, in whatever you do, do it with passion, do it with your efforts, put your energy, and at the end of it all, you'll be a beneficiary. As we come close to the festive seasons, we know that we have so many people who are targeting to cheat and, you know, in one way or the other, try to mistreat you, but this calls for vigilance, and you need to be vigilant. You check on your friends, see how they are doing, and find out whether they are always safe and healthy, so that we can all enter the new year as we are safe and sound. I shall be here next Tuesday, bring a different guest, and probably talking about a different topic that is important to you and to me and to the rest of the viewers out there. You have been a good audience, and see you next Tuesday, and have a lovely afternoon.
The Alternative Dig Talk. Real issues, real talk.